I'm Dr. Lydia Hayes from Cardiff University School of Law and Politics. This is my public lecture at RMIT in the summer of 2018. The topic is Paid Care Work, Labour Deregulation and Private Business, Lessons from the UK. My monograph, Stories of Care, a Labour of Law, is firmly rooted in the domestic context of the UK. It's about UK employment rights and labour laws. It's about the degraded and demeaned status of the UK care workforce and the legal and policy positioning of the home care workforce in particular, at the margins of the labour market. However, home care workers around the world occupy marginalised positions in national labour markets, hence my work has a deep international resonance. I want to thank the Centre for People, Organisation and Work for hosting me at RMIT and making this lecture possible. In the UK, the policy agenda of privatisation was prompted by the 1990 NHS and Community Care Act. Privatisation didn't happen straight away, mainly because social services professionals didn't think it was such a good idea. But as the pressure from central government mounted, it became harder to resist outsourcing of services. As early as 1996, research had shown that privatisation damaged care quality for two key reasons. First, there was a reduction in the continuity of care because it was inefficient for private businesses to match the same care worker with the same client. Also, corners were cut and visits were made shorter because it wasn't profitable to meet service specifications in full. The government's motivation for privatisation was to cut the cost of services, and cost cutting has proved irresistible to successive governments. The policy agenda of personalisation came after privatisation. It became widely accepted that collectively organised provision was paternalistic and insufficiently focused on individual needs and preferences. And personalisation required local authorities to introduce systems of direct payments for disabled people, aged under 65 initially, and then for people aged over 65. Direct payments, this was government money that could be used directly to purchase personal care from a company or to directly employ a care worker, a personal support worker or personal assistant. Personalisation has also led to every person who is assessed for care having an individual budget. So both privatisation and personalisation are aspects of a broader marketising agenda. Privatisation established the basic organisational building blocks of a market in care, and personalisation transformed how that market would be set to work. So marketisation is coming to Australia 20 years or so after it first took effect in the UK, and the hope is that lessons can be learned from the UK and that your marketisation won't create the problems that we are currently dealing with in the UK. So on that note, let me give you some headline statistics. There are 2 million workers in the social care sector in the UK, about 20,000 different care providers, employers, and an additional 65,000 individuals who employ care workers or personal assistants via direct payments. So you can see it's a highly fragmented market. Social care is the largest source of employment for low-waged women in the UK. We have huge labour turnover problems. The labour turnover rate in the social care sector is about 30% a year, rising to 40% in the home care industry. Official inspections by Her Majesty's Revenue and Customs find that half of all employers are not meeting their national minimum wage obligations. And this is largely because of the prevalence of industry expectations of unpaid working time. So let's look in some more detail at the minimum wage issues. The Living Wage Foundation calculates that a worker in the UK needs to earn £8.75 an hour to meet minimum everyday living costs, and that rises to £10.20 an hour in London. Now, the national living wage, which is the rate for an adult aged 25 years and over, is £7.83. So that rate is well below what is calculated as the living wage that's actually needed. But that's the rate that's set out in law. But researchers are often finding that the wages of home care workers, when averaged across the hours that they actually work, come in at about £5 an hour. And in my research, home care workers said that they were working for twice as many hours as the hours that they were paid for. Employers acknowledge across the UK that an average of 19% of working time in home care is unpaid because it's unpaid travelling time. And this is even though travelling time is eligible for inclusion within minimum wage calculations. The latest emanation of the minimum wage problem in the care sector is what's known as #sleep-in crisis. Employers haven't been paying workers for overnight shifts in individual homes on an hourly basis. They've been giving them a very small flat rate. And they face collectively a £400 million liability to repay wages that have been unlawfully low. The employers have said they can't afford to pay, and the government has stepped in to protect the stability of the market with a special compliance scheme in which wages don't have to be paid in full until March 2019. Now, in the meantime, there are ongoing negotiations with government. Employers are trying to reduce their liabilities, and the case is soon to be reconsidered by the Court of Appeal, so watch this space. Additionally, it's the industry standard to employ workers on 0 hours contracts, and this means that work is very insecure. Workers don't know from 1 week to the next whether they have paid work, and it's difficult for them to calculate their hours of work to know whether they've been paid in accordance with the minimum wage. There's no occupational sick pay and very little training. Where training is in place once employment has started, it frequently means letting a care worker sit in front of a computer screen to watch a DVD. Their time is unpaid, as is time spent in supervision meetings, waiting for doctors to arrive at clients' houses, waiting for co-workers to arrive, and many other instances. For service users, there's a crisis of care in relation to the very long waiting times which exist in some places between assessment and the provision of a service. And for those who do receive a care service, there is a fair chance that the service will be substandard. A fifth of all services, including 1 in 3 residential homes, are formally rating as failing to meet minimum standards. This is often on safety grounds, but always because minimum care standards are breached. And finally, we have an issue with elder abuse, and this problem is increasing. Last year, there were 70,000 formal investigations into reported abuse of a person aged 65 and over, and that was in England alone. It's a 7% increase on the previous year, and care workers constitute between 30 and 40% of those identified in abuse reports as the perpetrators of abuse. Abuse by a care worker can be physical, psychological, sexual, financial, but the most frequent and widespread category of abuse is that of neglect or omission, meaning that care workers are abusing older people by not providing them with the care and attention that they need. The charitable organisation Age UK undertakes a considerable amount of research about the care needs of older people in the UK, and its latest estimate is that 1.2 million older people who need help, for example, with washing, dressing, eating, toileting, medication support, preparing food, these basic essential human pursuits, they are not getting support at all. And the question around which this lecture is framed is, who should be ensuring that we are cared for safely in old age? And the way things are going, the UK's social care system is unlikely to survive the next few years. UK state support for social care provision is marked by chronic underfunding, and what I'm arguing in the book is that the lack of funding is not the nub of the problem. What lies beneath the lack of funding is the fact that paid care work is subject to persistent degradations of sexism and class bias. And these degradations in the organisation of care work are shaped by a collective history which extends back over the past century and continues to evolve. Contemporary harms inflicted on home care workers, their underpayment, insecurity, low pay and exposure to health and safety risks, they're felt collectively through this body of shared experience. And in my book I identify that care workers have been subjected to something I term institutionalised humiliation. And this is a process which underpins many of the failures of social care, and it's expressed through law and legal doctrine at work. Home care workers are impoverished, disrespected and marginalised through their work, and the structural undervaluing of their labour is embedded in the state-led organisation of the UK's home care industry. And with the term the state, I'm referring to the sum of power and responsibility carried by successive governments and the institutions that are key to the arguments I advance. So the judiciary, the legislature, the civil service, the Department of Health, local authorities. The institutional humiliation of home care workers is expressed in the state's denial to them of employment protection and in the imposition of barriers that serve to impede their ability to assert basic legal rights at work. My book is considering legal mechanisms which are key to the creation of institutionalised humiliation and which reproduce them in a contemporary context. In Australia, you use the terms aged care and disability care. In the UK, both areas of provision are covered by the term social care, and it's often defined in policy discourse by its difference from health care. That's because the National Health Service was created as a service free at the point of delivery by an Act of Parliament in 1946, whereas social care emerged from the 1948 National Assistance Act, and it's always been the case that local authorities have been able to charge and reclaim the costs of care from people who are thought able to be able to afford to pay. But in my work, I define social care in another way. I defined it as the antithesis of political conceptions in which care is regarded as a private matter into which the state shouldn't ordinarily intrude. Social care, I argue, is a consequence of care which has been socialised, and it is a political achievement that has changed the life opportunities of millions of men and women in the UK. It's been essential to the 20th century liberation of women because responsibility for care has been lifted out of the private sphere of the family and made into a social responsibility. Now, to be fair, this isn't complete, it's flawed. Responsibility for care hasn't been taken up by men to any great extent. We don't have equality between men and women, but there is a clear public responsibility for the care of citizens, and this is expressed in the concept of social care. So I want to say something not about the problem of the profit motive in marketised care, but about privatisation. Even though family life is centrally shaped by government and legislatures in relation to taxation, legal norms, social welfare, education, housing policy, it is commonplace to regard domestic homes as private spaces where people live so-called private lives. And similarly, despite government investment in roads, education, transport, infrastructure, and the instigation of an administrative and legal framework in which privately owned businesses are able to thrive, economic markets are considered to be private, and they stand in contradistinction to the activities of the state. So what the privatisation of social care does is it mixes the economically private realm of the market with the socially private realm of home and family. Private sector organisations dominate the care landscape in the UK, but on occasions, local authorities have given commercial contracts to not-for-profit social enterprises or voluntary organisations, and this has given rise to the use of the term independent sector as the collective noun for the non-public organisations that deliver care. By drawing attention to the independence of non-public provision, the term tends to deflect attention from the private economic interests that are served when public sector services are contracted out. Yet, independent is a strange word to use for enterprises which exist predominantly through their receipt of billions of pounds of public money. It's true that the ethos of charitable and not-for-profit organisations isn't the same as the ethos of private sector organisations, but in the context of privatisation they bear remarkable similarities. As holders of commercial contracts, they all must operate on a commercial basis and all engage in competitive tendering. Private, social enterprise and charitable organisations populate an independent sector which has been strategically positioned by successive governments to compete with the public sector. In care, competition for contracts is a competition over labour costs, and it's one which the independent sector has won hands down. In the UK, the care workforce of today is employed in jobs which carry less than half the equivalent financial value of the jobs that care workers occupied 20 years ago. The publicly funded occupational pension, the occupational holiday, the occupational sick pay, that's all gone. Hourly wages have been slashed. The system whereby workers were paid for every hour that they worked, that's gone. I argue in my book that the independence of the independent sector rests in its legal capacity to locate the employment of care workers at the margins of the labour market. So its primary distinguishing feature is a legal independence to employ care workers on lower pay and according to lesser terms and conditions. Independence in pay setting is the major driving factor in the privatisation of social care. Because of the inadequacy of employment laws, the weakness of employment rights, and the lack of regard for labour inspection and enforcement in the UK, the independent sector is able to eliminate the costs of protecting care workers from the economic impacts of sexism. Currently, over 1 million adults in the UK have given up paid work to care for friends and relatives. Most of these unpaid carers are women, and in large part they exit the labour market because social care provision is inadequate. Meanwhile, life has also become much harder for the women who are paid to provide social care. They have faced a regressive, sexist and systematic subordination of their interests as women and because they are women. The inadequacy of the regulation of employment is important for understanding what has happened in the care sector in the UK in recent years, and critically for understanding how it has happened. The basic tenets of the post-war social care settlement between the state and the British people, in which the state carries responsibility for meeting care needs, these are under systemic political attack. For example, a major speech by Jeremy Hunt MP, Secretary of State for Health, illustrates how conceptions of excessive dependency are deployed as political justifications for the erosion of care services. In talking to the Local Government Association conference in 2015, he characterised Britain's ageing population, their needs as being a burning platform upon which public services stood. He warned, if we are to rise to the challenges we face, taking care of older relatives and friends will need to become part of everyone's life. He chastised his audience in relation to what he called our national shame, in which 1 in 10 older people have contact with their family less than once a month. And he sounded a warning bell that this national picture is far from kind and far from decent. His underpinning message, that dependence on the state is repugnant, the implication is that there is a threat to the social fabric of the nation, because it's presumed that when women fall short of their family obligations, and I'm saying this because care within families is gendered, they are also erring in their duty as responsible citizens. Meanwhile, the Health Secretary in his speech praised the magnificent work of the nation's 6 million unpaid carers, but he didn't mention paid care workers, not even once. It's hard to imagine that a major political speech by a government minister could be made about the health service without mention of the doctors and nurses who populate it. However, such is the humiliation of home care workers that they not only pass without acknowledgement, but their work is represented by the government as an excess of state dependency, a symbol of social weakness and an indicator of national shame. A further example, Dr. Philip Lee MP. He intervened in a House of Commons debate about the abuse of older people in residential care homes to ponder why our society outsources the care of elderly loved ones to the state. He proposed that the abuse of older people in residential care would be remedied if elderly relatives were looked after by their own families rather than the state. Setting aside his failure to take into account the frequency with which older people are exposed to abuse by family members, his political perspective rests on gendered assumptions about family responsibility and a class-based rejection of universal state support. It's also the case that judges in the UK's highest courts do not shy away from asserting that the care of the elderly is not a fitting responsibility for the state. In the case of YL and Birmingham City Council, Lord Mance expressed, "I do not regard the actual provision of care and accommodation for those unable to arrange it themselves to be an inherently government function." In support, Lord Neuberger asserted that the provision of care is not a function which is intrinsically of a public nature. When tasked with shaping the responsibilities of the state in relation to the future of social care, it's evident that people in positions of considerable decision-making power may be predisposed to regard care as a private matter and believe it ought to be provided by families, presumably as the unpaid labour of women. According to this view, intervention by the state feeds social dependencies and disrupts patterns and rhythms of class and gender which are assumed to represent a pre-existing, natural and morally robust social order. It is the site of a titanic ideological clash within which the working lives of home care workers are situated. People who regard care as a private matter are responsible for the distribution and upholding of public standards and entitlements which are explicated in employment law. Labour standards, whether derived from common law or from statutory rights, are public standards. This point has been reinforced in the 2017 decision of the Supreme Court in Unison and the Lord Chancellor, in which fees to use employment tribunals were quashed. Minimum labour standards and employment rights are publicly deliberated, publicly available, and represent the publicly settled terms upon which Parliament has decided employment relationships should rest. These should not be denied to care workers. This is not only a moral argument or a rule of law argument, it is an empirically grounded argument based on the impact of deregulated employment on the quality of care provision. My book, Stories of Care, A Labour of Law, is based on the experiences of 30 home care workers from the same city in the south of England. In it, I use the words of home care workers as tools with which to illuminate their working lives and to try and understand how labour law intertwines with the materiality of paid caregiving. The stories which care workers shared with me are an important and distinctive source of knowledge upon which broad understandings of law and society can be built. Inevitably, it's not possible to draw general conclusions just from the accounts of 30 individuals, but when the data I gathered is set in a wider research context, when it's shown to fit with what else is known about the working lives of home care workers, it becomes possible to say something meaningful. At least that has been my aim. Saying something meaningful is important because there are few better examples of the contempt of the UK state for working class women than can be found in the treatment of the social care workforce, particularly over the last decade. Each chapter of the book identifies ways in which the labour market participation of paid caregivers is widely judged as inferior by judges in courts of law, by politicians, by legislators, by policymakers, government, employers, and in the media. And what I show in the book is how these judgments of inferiority are legitimated by legal provisions and judicial doctrine. This is because in law we find a body of reasoning in which care workers are inferior, where they do supposedly deserve less, where they are markedly different from other types of workers, where they have to meet different tests of entitlement, in which they're not considered to be proper because they do women's work. Chapter by chapter in the book, I argue that the UK's crisis in social care is co-implicated with the gendered injustice of inadequate labour law. I analysed my data by identifying and categorising the different types of narratives which rested in care workers' expressions of their own experience, and I drew these together in what I call character narratives. In the first chapter, I begin by collating care workers' stories about low pay, being undervalued at work, and assumed to lack distinct skills. This is the character narrative of Cheap Nurse, and I set her in the historical context of the development of home care services in the UK and the evolution of equal pay law. Equal pay law has done very little for women who work where men do not, and in care work, equal pay law, its inadequacies, have incentivised and justified the privatisation of care services. In Chapter 2, I discuss a range of stories told by care workers that I characterise under the name of Two a Penny. These are stories about insecure work, working on a 0 hours contract, and the damage done to women's self-confidence and family lives by their lack of economic security. It represents their stories of being tricked by employers into taking jobs on false pretences, of working without any perceived barrier between the time they are potentially available for work and when they know they can rest, of being short-changed on wages, but above all, of being fearful of instant dismissal. From this perspective, I explore employment protection law, unfair dismissal provisions, which are primarily available to people with secure contracts of employment and with 2 years of continuous service. And I also look at what are called 2P provisions, the transfer of undertakings and protection of employment regulations. These are supposed to provide protection of employment contracts when services transfer between one business owner and another. But employment protection law doesn't protect the type of employment in which care workers are typically engaged, and I show that this is because they are mainly working class women, and the law is not really designed to protect them. Employment protection law is designed to facilitate the stability of traditionally or typically male employment in ways which reflect notions of female inferiority. So if we take the example of 2P protection, say a local authority is contracting out some function and it divides the work between several different contracting companies. The law says that it's not possible to identify the organisation to which each individual job as a whole has been individually transferred. And in those circumstances, the employment contract isn't protected. A worker is consequently in a redundancy situation rather than continuing to have a job. And this fragmented contracting is possible to do in work providing a flexible, fluid, human, one-to-one service to lots of different clients. It's not possible to do where the services being contracted out are based on machinery or labour associated with a physical location. So accordingly, male-type jobs like driving a bus or working as a security guard or on a building site, these jobs are protected by 2P regulations. But female-type jobs, like caring for 10 different older people for 3 hours a week in 6 half-hour visits, this work gets fragmented by contracting across several providers, and individual employment contracts are not protected. And this strategy of fragmented contracting was purposefully used in the UK to deny employment protection to care workers. In the local authority area where my research was based, the work of one local authority was divided across 50 different private providers, and none of the local authority care workers kept their jobs. They were all made redundant. The next character narrative is that of Mother Superior, and she narrates care workers' stories about working for love, not for money. I found that care workers are often so horrified by what is happening in their occupation that they need to distance themselves emotionally and intellectually from being associated with inadequate care and from the abuse of older and disabled people, which is on the rise. And they do so by talking about themselves as dedicated carers, not like the other carers who are the source of these problems. I set this story about the dignity that they find in valuing unpaid labour because they explain that dedicated carers will do the work that's necessary regardless of whether they're being paid. These stories are set in the context of the failures of national minimum wage law. It's lawful to be required to perform some contractual duties without pay. National minimum wage law is concerned with the total amount of pay in a pay period, and the number of working hours a worker has engaged in is divided by the total amount of their pay. There's no requirement for the employer to clearly share with the worker the number of recorded working hours. The concept of work is controversial in social care. Employers, for example, are lawfully permitted to require workers to sign what are called daily average agreements, in which the employer and worker agree that in, for example, a 15-hour shift in an older person's home, only 6 of the hours are taken up with providing hands-on care, and therefore only 6 of the hours are to be included in the national minimum wage calculation. This problem that the law has in understanding care as work takes many different forms. I'm going to give you some examples now, one from judicial interpretation and one in relation to statutory exemption. So, for judicial interpretation, let's look at the case of Al-Malki and race. Article 31 of the Vienna Convention on Diplomatic Relations provides immunity to diplomats, except in relation to legal action relating to any professional or commercial activity exercised by the diplomatic agent in the receiving state outside his official functions. Now, this diplomat employed a care worker in the home of his family, and the care worker was abused and exploited. The question before the court was whether she could make a claim for minimum wages that were owed to her, or was she prevented from doing so because her employer had diplomatic immunity from prosecution. According to the Court of Appeal, in relation to a care worker who they acknowledged had been abused and exploited, the fact that an employer derives economic benefit from paying his employees wages that are lower than the market rate doesn't mean he is engaging in commercial activity. The question as to whether an employer is engaged in a commercial activity depends on what the individual is employed to do. So what the Court of Appeal have decided here is that if the work which is commissioned by an employer is care work in a domestic location. It is not commercial. And in this instance, it meant that the care worker was unable to pursue her minimum wage claim. Let's look at statutory exemptions. When a worker lives in the same home as her employer and she's treated like family, the employment contract can be exempt from national minimum wage protection. The test of being treated like family is based upon the sharing of leisure activities and meals. And when the Court of Appeal came to apply that test, in the case of Nambalat and Tyre, they looked at whether a care worker was able to claim national minimum wage protection or whether she was treated like family as a family household worker. Now, what happened was that Nambalat had helped to prepare meals, but her contract only required that she cleaned up after meals. So this work was viewed as being more than was necessary under her contract. Doing more work for the family indicated that she was participating as a family member. Her work was viewed through a family lens. So the fact that she did more than was required of her actually meant that she ended up being exempted from minimum wage protection. This is even though her employment contract was perfectly valid and lawful. So what this indicates is that while the Mother Superior narrative shows that care workers have an enormous amount of pride in undertaking work without pay because they do care, these care workers are exploited because employment law provides extensive justification for the idea that care work is not as worthy as other forms of work and that it is acceptable and rational for care work to be provided without pay. In Chapter 4, the final character narrative is that of Choosy Susie, and she represents the stories of care workers who were operating on a self-employed basis or employed as personal support workers or personal assistants. I show how the employment impacts of the 2014 Care Act in England uncover a discourse of service user choice and personalisation, which is used to undermine the rights-bearing identities of care workers. So the Choosy Susie narrative captures various ways in which notions of choice are played out in the private domestic locations where paid caregiving takes shape. Choosy Susie stories were communicated in a distinctive discourse which included core phrases like promoting independence, enabling people, and support for living well. In these Choosy Susie stories, care workers were expressing their motivation to give care by giving people choice who otherwise lacked choices or autonomy. However, on the facts of these stories, I was intrigued by twists and turns in events which were about how the agreements broke down over issues of pay or hours of work. There were many very difficult judgment calls that women care workers were having to make, working alone without any backup. There were many stories of accidents occurring due to unsafe working practices and in the absence of specialist equipment. Care workers and their employer clients were clearly sometimes struggling in their relationships with one another. So, what was the relevance of choice for workers' employment status? Self-employment represents just over 10% of the size of the care-at-home workforce in the UK. And since 2010, self-employment has grown more rapidly for men than for women, but care work is the largest occupational activity for women who identify